So, Representative Brandon Gill, a freshman Republican from Texas, whose primary qualification seems to be his unwavering loyalty to Donald Trump, decided to use his time in the House Judiciary Committee to try and grill former Special Counsel Jack Smith. The topic? Smith's investigation into the attempts to overturn the 2025 election. Specifically, the fact that Smith subpoenaed the phone records of Kevin McCarthy and several other Republicans. Gill thought he had a gotcha moment about a non-disclosure order, but no, he's confusing standard procedure with a conspiracy. As usual, let's watch this hearing, and I will give you my breakdown of it later.
Texas, Mr. Gill is recognized for 5 minutes.
All right, buckle up, folks. We just witnessed a masterclass in political theater where a freshman Republican tried to corner Jack Smith. And honestly, it went about as well as trying to teach a cat to play the piano. The goal? To make it seem like Jack Smith, the special counsel investigating an attempt to overturn the 2020 election, was some rogue agent, spying on patriots, doing something ridiculous. But let's be real. What we actually saw was a desperate attempt to muddy the waters and distract from the real issue, which is accountability. We're going to deep dive into this performance, pick apart the flawed arguments, and get to the truth of what's really going on here. Let's roll the tape.
Mr. Smith, in January of 2023, did you subpoena then Speaker of the House Kevin McCarthy's toll records?
Yes, sir, we did.
Yes, you did. And the subpoena covered the time period between November 2020 and January 2021. Is that right?
I'm sorry, sir. Could you say that again?
We're not going to delay like this. The subpoena covered the time period between November of 2020 and January 2021. How many days after Kevin McCarthy was sworn in as Speaker did you subpoena his records?
I don't recall, but those two things had nothing to do with one.
It was 16 days after becoming the highest-ranking Republican in the House of Representatives. You subpoenaed his toll records. Do you agree that that might reasonably be considered a violation of the speech or debate clause?
I do not, and I want to be clear that the toll
You
records...
were collecting months' worth of phone data on the Republican Speaker of the House, the leader of the opposition, right after he got sworn in as Speaker, all around the time of a major vote. That sounds like a flagrant violation of the speech or debate clause to me, and I think most people agree with me. And Speaker McCarthy had no recourse, did he? Because you issued a non-disclosure order ensuring that neither he nor any of the American people knew about these subpoenas. Is that right?
The toll record, the non-content toll record subpoenas, we did secure non-disclosure orders for those subpoenas.
You did, and let me ask you, Mr. Smith, at the time you secured those non-disclosure orders, was Speaker McCarthy a flight risk?
The non-disclosure order was based on concerns about...
Was Speaker McCarthy a flight risk?
He was not.
He was not. Then why did your non-disclosure order refer to him as a flight risk? It says right here, the court finds reasonable grounds to believe that such disclosure will result in flight from prosecution.
Whoa. Hold your horses there, Representative Gill. Did he just try to imply that Jack Smith thinks Kevin McCarthy is going to pull a great escape out of Congress? This is peak performative outrage right here. It's like accusing the chef of thinking you're a cannibal because the recipe calls for humanely raised meat. The language on legal forms, especially those designed to protect investigations, often include a range of boilerplate justifications. They're not custom-tailored psychologically profiles for every single person. This isn't about Jack Smith personally believing Kevin McCarthy is going to don a disguise and flee to a non-extradition country. It's about the legal framework that allows prosecutors to secure non-disclosure orders to prevent any potential disruption to an investigation. This includes things like the destruction of evidence or tampering of witnesses, which, let's be honest, are far more plausible concerns when you're investigating powerful political figures who have a lot to lose. To fixate on a flight risk line as some kind of smoking gun is willfully ignorant, or at worst, deliberately misleading. It's a classical misdirection tactic. Focus on one specific, easy, sanitized phrase in a legal document to distract from the actual, very serious reasons why these records were being sought off in the first place. They want you to gasp at the idea of McCarthy being called a flight risk, so you don't ask why his phone records were so important to investigate. It overturned an election. It's a shiny object to keep you from looking at a man behind the curtain, or in this case, the evidence behind the subpoena.
Sir, when securing a non-disclosure order, the risks don't have to be
You
associated.
think that the Speaker of the House is a
Finish
flight
answering the
risk?
question?
No, this is not your time. This is my time. You think the Speaker of the House is a flight risk? You think he's going to hop on a plane and leave the country?
No, what I was trying to explain is with respect to a non-disclosure order, the risks aren't necessarily associated with the subscriber to the phone. They're the risks to the
Okay.
investigation.
I think that you were using, this was clearly in reference to Speaker McCarthy, and you were using clearly false information to secure a non-disclosure order to hide from Speaker McCarthy and from the American people the fact that you were spying on his toll records. But I've got more, so let's move on. In May of 2023, you also issued subpoenas for toll records of 9 U.S. senators and an additional representative. Is that right?
In May of 23, we did issue.
You did, and there were non-disclosure orders in conjunction with those subpoenas as well, right?
That's correct, consistent with department policy and
Right.
the law.
So again, nobody would know what you were doing. The senators would, and the representatives would, and the American people wouldn't know what you were doing. Is that right?
The toll records that we secured and the non-disclosure orders were consistent with policy and consistent.
And you knew whenever you were doing that there was a risk you were violating the speech or debate clause. Is that right?
The toll record subpoenas that we secured were with the concurrence of the public integrity.
Your own analysis says that you knew there was a risk you were violating the speech or debate clause. I have it right here. This is an email from John Keller at Public Integrity Section to your team.
Oh, the infamous litigation risk email. Gill, he's acting like he just uncovered the mecca of all meccas. But let's pump the brakes for a second there, buddy. This isn't about confession. It's literally just how lawyers operate. When you're dealing with complex legal issues, especially those involving constitutional clauses like the speech or debate clause or a competent team, any competent team is going to assess potential risks. It's called due diligence, folks, not a conspiracy to undermine democracy. Imagine a construction crew building a skyscraper. Do they just start digging without consulting engineers about a potential structural risk or soil stability or zoning laws? Of course not. They assess all the risks, plan for them, and then they proceed. This email is the legal equivalent of an engineer saying, hey, there's a chance of hitting bedrock here, so let's have a plan for it. It doesn't mean that the secretive trying to collapse the building. It means they're doing their job responsibly. The speech or debate clause is meant to protect legislative acts, not shield politicians from accountability or for potential criminal behavior, especially when it involves attempts to subvert an election. To suggest a lawyer acknowledging that litigation risk means they're knowingly violating the Constitution is profoundly misunderstanding of legal practice, or more likely, probably what this is, a deliberate distortion. It's like saying a doctor who discusses the risk of surgery is admitting they're trying to harm their patient. It's absurd. This is just another attempt to weaponize standard legal procedure against those investigating powerful figures. It's annoying.
As you are aware, quote, as you are aware, there is some litigation risk regarding whether compelled disclosure of toll records of a member's legislative calls violates the speech or debate clause in the D.C. Circuit. That's from your own analysis right there. So you did know, didn't you?
Sir, with respect to the item you just put up on the screen, the last sentence states.
Oh, we're going to get to the last sentence.
Okay.
We're going to get to the last sentence. And you cite case law in here, quote, the bar on compelled disclosure is absolute. Is that right? Or do you think that you didn't have to abide by that precedent?
To be clear, this statement is not from my office. This is the statement
This
of
is
Public
this is your
Integrity
justification for those subpoenas and NDOs that you ordered. This was part of your analysis. It's a cursory analysis. I think it's worth noting. But let's get to that last sentence then. Quote, given my understanding of the low likelihood that any of the members listed below would be charged the litigation risk should be minimal here. In other words, you're using a novel legal theory, which you knew was novel, has never been tested by any court. You're not charging any of these members. Nobody's going to know about it because you issued NDOs. Nobody's going to sue this, so who cares? We're going to do it anyways. I mean, you walked all over the Constitution throughout this entire process.
Mr. Chairman, the gentleman's time's
spying
expired.
on members of Congress, and you know it. It's absolutely disgraceful. I yield back.
And there it is, folks. The grand finale. Disgraceful. Walked all over the Constitution? Gill wraps up his performance with all the subtleties of a bull in a china shop. But let's be crystal clear here. When he demonized or demonstrated wasn't a defense of the Constitution. It was a desperate attempt to create a smokescreen. He's trying to make you believe that the investigating potential crimes by powerful politicians is the real affront to justice, not the alleged crimes themselves. Unfortunately, it's a classic tactic. When you can't defend the substance, attack the process. It's like a child who gets caught with their hand in a cookie jar. And instead of them admitting, hey, I took the cookie, they start screaming about how unfair it is that the cookie jar was so high up on the shelf. The entire argument hinges on the premise that politicians, especially their politicians, let's be honest, should be immune from scrutiny, especially when that scrutiny involves looking at who they were calling on or doing during the coup attempt anyway. The speech or debate clause, it's not a get-out-of-jail-free card for anyone or everyone in the Congress and with a congressional ID. And demanding that investigators announce their intentions to potential subjects before securing evidence is just, well, it's actually hilarious if you think about it, if it wasn't so serious. That's not how investigations work in a democracy. Unless you're living in some sort of honor system from alleged criminals' fantasy land. Jack Smith, by all accounts, followed the law, got court orders, and did his job. The disgraceful thing here is the investigation. It's the transparent effect to weaponize a congressional committee by intimidating future investigations into a political malfeasance. It's a chilling effect, plain and simple, designed to put powerful people above the law.
Okay, let me just validate the feeling you probably had while watching that. It sounds scandalous, doesn't it? The idea that the Department of Justice was spying on the Speaker of the House and labeling him a flight risk, like he's El Chapo planning a tunnel escape. I mean, look, to be fair, seeing how fast Kevin McCarthy fled from his principals to Mar-a-Lago after January 6th, maybe flight risk isn't totally inaccurate. Or maybe it is. I don't know. But if you're feeling outraged, it's because Gill is banking on you not knowing how the law actually works. And honestly, that tactic works way more than it should. So I went ahead and looked up the actual statute that Jack Smith was operating under, because Gill certainly wasn't going to read it to you. The authority for these non-disclosure orders comes from 18 U.S. Code Section 2, 705, subsection B. And according to the text of the law, a court shall grant one if notifying the person would result in any of 5 specific consequences. Gill kept hammering on number 2, flight from prosecution, but he conveniently ignored the other options, specifically number 3, destruction of or tampering with evidence, and number 5, seriously jeopardizing an investigation. When prosecutors file these forms, they often check multiple boxes, because tipping off a suspect, or even a witness, can lead to deleted texts and coordinated stories. It's not that they think Kevin McCarthy is going to defect to Russia, it's that they think he might accidentally delete his call logs. Whoops, just slipped right out of the phone. And let's talk about what toll records actually are, because the word spying is doing a lot of heavy lifting here. Toll records are metadata. It's logs of who called who, when, and for how long. It is not the content of the calls. They weren't listening to Kevin McCarthy order pizza or beg for votes, which, now that I say it out loud, honestly, that would be kind of funny, but no, that's not what this is. And as for the speech or debate clause, Defense Gill is clinging to the idea that members of Congress are immune from legal scrutiny. The Supreme Court has generally held that this protection applies to legislative acts. It is not a blanket immunity shield for potential criminal conspiracies involving overturning an election. The litigation risk email Gill waved around wasn't an admission of guilt. It was a lawyer doing their job assessing the likelihood that a member of Congress would sue them to slow down the investigation. Which, Yeah, of course they would. That's not a conspiracy, that's just a Tuesday. What we are witnessing here is a deliberate strategy to conflate accountability with persecution. By focusing on the process of the investigation, the forms, the checkboxes, the timing, Gill is trying to distract from the substance of what was being investigated. They want you to be mad about the non-disclosure order, so you forget why Jack Smith needed to see who the Republican leadership was talking to in the days leading up to January 6th. And, I mean, come on, if it was totally normal, they wouldn't be acting this weird about it. So here is the simple truth you can tell your friends. Prosecutors don't ask suspects for permission to check their phone bills. They don't. They can't. That's not how any of this works. If Jack Smith had told Kevin McCarthy he was looking at his records, the evidence would have vanished faster than McCarthy's speakership, which, still kind of incredible, honestly. Like, record speed. So, what does this mean? On a personal level, imagine if the police had to ask a bank robber for permission before checking the security cameras. That sounds ridiculous because it is. Yet, that is the standard. Republicans want applied to themselves. It's a level of entitlement that says, laws are for you, not for us. And if you or I were under investigation for a federal crime, we wouldn't get a courtesy call from the Department of Justice. We'd get a knock on the door, and probably not a friendly one. On a broader scale, this is an attempt to criminalize the investigators. By dragging Jack Smith in and shouting about novel legal theories, they're trying to ensure that no future prosecutor ever dares to look into the phone records of a Republican politician again. It is a chilling effect designed to place the political class above the law. And for what? To protect the reputation of Kevin McCarthy, a man who has already been humiliated by his own party? No. It's to establish the precedent that if you have an R next to your name, your phone records are sacred even if they contain the blueprint for a coup. The reality is that Jack Smith followed the Department of Justice's own guidelines, consulted with the Public Integrity Section, and obtained a court order from a judge. Gill can scream disgraceful all he wants, but the only disgrace here is a member of Congress using a committee hearing to act as a defense attorney for potential co-conspirators. And wow, what a use of taxpayer-funded time. Fantastic. This isn't about the sanctity of the Constitution or the speech or debate clause. It's about fear. It's about the terrifying realization that there is a permanent record of who they were talking to when they thought no one was watching. And based on how hard they're fighting to keep us from seeing it, I'm guessing it wasn't just their grandmother.
So, what's the takeaway from this whole charade? It's simple. Don't let them gaslight you. Don't let them distract you with legal jargon and manufactured outrage about flight risks and litigation risks. The real question isn't whether Jack Smith followed every bureaucratic comma. It's why Kevin McCarthy's phone records from around January 6th were so important to begin with. They want to make it taboo to investigate political politicians, and very powerful ones, especially when those politicians are caught up in something as serious as trying to turn over the election. This isn't about protecting the Constitution. It's about protecting themselves from accountability. We need to remember that no one, absolutely no one, not even the Speaker of the House, is above the law. If you found this breakdown helpful, if you're tired of these political games, hit that like button, subscribe for more truth-telling, and share this video to help others see through the smoke and mirrors. Let's try to keep calling out the bullshit together.